We are going to hear arguments starting with, you gave me that sheet and I lost it already. Here we go. Starting with the State of Ohio versus Charles Brown. That's case number 18CA011310. Both parties have counsel present today, so each will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. If you're going to reserve time, let me know and I'll try to keep you appraised of the time. The oral arguments are recorded and presented and posted on the court's YouTube channel, so we ask that you stay at the podium and keep your voice up so we get a good recording of that. We've read the briefs and we are ready to proceed if you are.
Good morning. May it please the court, Stephen Bradley on behalf of defendant appellant Charles Brown. I would respectfully reserve 5 minutes of my time for rebuttal.
I'll let you know when you get close.
Thank you very much. Your Honors, the primary issue in this case centers around what can and cannot constitute a criminal attempt under Ohio law. Both parties agree that words alone are not sufficient to constitute an attempt, and instead there is a requirement that the state present sufficient evidence to show conduct, affirmative conduct, that would represent a substantial step towards the completion of the underlying offense, in this case attempted sexual battery and child endangering. And the state would cite the court to certain testimony in the record that would suggest that the complaining witness in this case talked about the fact that she had been grounded by her father for unruly behavior, and that she could only be taken off punishment or ungrounded if she were to participate in these sex lessons that he had been talking with her about. But I would suggest to the court that if you look further in that same portion of the transcript where the complaining witness talks about the grounding, which is roughly pages 145 through 165 of the transcript, that in fact those words about grounding are likewise just words alone. That in fact she really was not grounded, that she goes on to describe where she was free to go to work, where she got into an argument with her father and she left the house and she was permitted to do so. She in fact called her grandmother at some point. She left the house to go report this incident to the police, who in turn directed her to record her father's conversation. So my point is that the state wants to direct you and argue to you that there was in fact more than just words here, that there was this affirmative conduct in the form of grounding. But when you look further in the transcript, you'll see that the grounding, the reference to the grounding, was words alone, that there was no affirmative conduct. And if there was, through this grounding, some minimal infringement upon, her teenage freedoms as a result of her previous unruly behavior, that is not conduct that would represent a substantial step towards committing the offense of sexual battery. It's, when we look at some of the other cases that we've cited in our brief, I'll specifically cite you to State v. Bowers, which was a second district opinion from 2001, and other cases cited in the state's brief, State v. Curtis. Those cases are classic examples of the sort of conduct that represents a substantial step. Words alone soliciting sex from a minor, together with, dropping his pants, exposing himself, directing somebody to perform oral sex. That is the sort of conduct that is required to establish the intent through that affirmative conduct. But more importantly, it sheds light on the facts of this case that we don't have any of that. We have nothing more than just mere words, both as it relates to talking about these sex lessons, which we know in and of itself is insufficient as a matter of law to constitute the attempt. And more, then when we look to the discussions regarding the grounding, same thing, just words. The complaining witness talks at length about how she was largely free to do what she wanted, despite the idle threat of being grounded. And again, more importantly, that grounding, that infringement on some of her teenage rights cannot be considered a substantial step towards the completion of a sex offense. It's undisputed that there was never any actual sexual conduct here. There was never any efforts to pin her down in her room, never any efforts to expose himself, anything that would more traditionally be considered a substantial step. So as a matter of law, there is insufficient evidence to establish a conviction under count 1 for attempted sexual battery. Moving to count 2, it's really a two-part analysis there. That same argument, the attempted child endangering requires the substantial step, and the child endangering count is predicated on the attempted sexual battery offense. And so again, two steps analysis there, that the same argument that there is no substantial step, there is no affirmative conduct that would give rise to the attempted sexual battery, so necessarily we would have insufficient evidence as to count 2, which is the attempted child endangering. And then the second argument, if you will, regarding count 2 and the sufficiency of the evidence would center around there's no evidence whatsoever that Mr. Brown knowingly or purposely intended to torture or cruelly abuse his daughter. There's just no evidence here whatsoever.
No medical or psychological testimony at all?
I'm sorry?
No medical or psychological testimony at all on that issue?
There was certainly no medical testimony, and there was some testimony from the complaining witness that she was depressed as a result of these conversations that were taking place between her and her father. But that would not, I think the legislature intended on the torture or cruelly abuse aspect of child endangering focused largely on some sort of physical abuse. And I think that's set forth in the legislative history where they discuss that. And there's no evidence whatsoever of any torture or abuse here whatsoever.
Could it be mental?
No. The state of Ohio has cited, don't have the name of the case at my hand, a case that would suggest that the reading the textbook definition of the Black's Law dictionary definition of torture and abuse could contemplate some sort of emotional abuse, but it goes on to analyze the case consistent with the legislature's intention that it all be some sort of physical abuse. So I would say no is a direct and simple answer to your question.
Thank you. You're at about 6 minutes and 20 seconds now, so.
Thank you. So moving on then to the third assignment of error that would relate to the notion that the there is not a cognizable offense under Ohio law where we have an attempt at a strict liability offense. That largely relies on the Supreme Court's decision in State versus Nolan from 2014 that essentially holds that the language in an attempt that requires the culpable mental state of knowingly or purposely is incongruous with a strict liability offense that has no mens rea whatsoever. And essentially, I believe that the State versus Nolan sets forth the proposition that the Ohio legislature did not intend to criminalize an attempt of a strict liability statute. And that's what we have here. There's no dispute that sexual battery as charged is a strict liability offense. And we have the attempt statute that requires some culpable mental state purposely or knowingly. And again, for the reasons somewhat analyzed under Nolan, that cannot lie. That is incongruous, so that pursuant to assignment of error number 3.
And I just want to let you know you're at 5 minutes left total right now, so you can continue if you want.
No, in fact, I would
Well,
conclude now and have the remaining time for rebuttal.
All right, you'll have 5 minutes for rebuttal. Council, you'll have 15 minutes, of course.
Good morning, Your Honors. May it please the Court, Lindsay Poprocky on behalf of the State of Ohio. As we've heard from Brown's counsel, this appeal centers on a father's attempts to torture his daughter, 17 years old at the time, and his consistent attempts to engage in sex with her by repeatedly and graphically telling her that she would not get off the punishment that he imposed upon her unless and until she engaged in sex with him. Because of this conduct, Brown was convicted of attempted sexual battery and attempted child endangerment. Initially, the state submits that taken in the light most favorable to it, the evidence presented was sufficient to support Brown's convictions for those attempts. In his brief, Brown asked this court not to criminalize his behavior. But the circumstances of this case go beyond the mere approval or disapproval of his parenting style. Rather, not only did Brown's conduct cross the lines of all decency, but he took a substantial step towards the completion of the 2 criminal acts, which renders him guilty of those attempts. It's important to note that Brown began engaging in conversations with his daughter about what he called sex lessons when she was as young as 14 years old. But it was not until she moved into his home at the age of 17 that the sequence of events began, which culminated in his attempts to commit the crimes which he was convicted of. Once Steve B. moved into Brown's home, Brown was in a position of authority over her, and at a certain point placed her on punishment. Brown then used that authority and the imposition of punishment as a coercive tool in his repeated discussions with DB, where he told her with language that was admittedly coarse and pointed, and that was heard by the jury through audio recordings, that unless and until she engaged in sexual conduct with him, she would not get off that punishment.
The grounding.
The grounding.
And was she in fact grounded? And counsel said she was free to leave the house to, was she grounded?
I believe, and the testimony would relate, that she was grounded, and that in the audio recordings that you will hear that he repeatedly told her, you will not get off this grounding unless and until you have to engage in these sex acts. So I would dispute that testimony.
Was there any testimony that she was prevented from going places, attending extracurricular school events or anything like of that nature?
She testified that she felt blackmailed and that she felt that he was preventing her from going anywhere, engaging in activities with her friends, and that was her testimony. So the essence of Brown's argument is that his conversations with DB, where he told her she had to give him sex lessons, are insufficient evidence of attempt because they were mere words. It's important.
Was the grounding imposed because she wouldn't engage in any acts with him, or was the grounding imposed for something altogether different?
The grounding was imposed for something different because of behavior that, like Brown's counsel said, she had been behaving unruly. I think it's important to look at the actual elements of attempt as they have been construed by the courts. And the elements of criminal attempt are the mens rea of purpose or knowledge and conduct directed towards the commission of an offense. Therefore, a criminal attempt is complete when a defendant's conduct constitutes a substantial step in a sequence of events designed to result in the perpetration of a crime. And a substantial step involves conduct which is strongly corroborative of the criminal actor's purpose. And therefore, the definition of attempt does focus on a defendant's conduct, which begs the question whether words can be conduct. The state submits that the use of words and the manner in which they are expressed can be viewed as conduct, which is corroborative of a person's purpose and can be further used to put other conduct into context.
Is there case law precedent on that point?
I do not have anything cited to support that. Here, Brown continuously discussed the need to teach and show DB how to engage in sexual conduct and impose punishment on DB unless until she engaged in the sex acts. We're submitting that based on Brown's words coupled with his overt actions, this constituted a substantial step in a course of conduct and strongly corroborated his criminal purpose. As to the second count in the indictment for attempted child endangerment, that was charged under the torture and cruelty abuse section. And we would note that those terms are not defined in the Ohio Revised Code and cited to the case out of, I believe, this district, State v. Nyberg, that torture can be the infliction of severe pain or suffering of body or mind. And here there was testimony by Brown's daughter that these conversations and the consistent discussion of sex lessons caused her to be angered and saddened. She felt blackmailed, that she would never get off this punishment unless and until she engaged in sex lessons with her father, and that she was depressed as a result. As to Brown's argument that one cannot commit a strict liability offense, and he argued that based on State v. Nolan, the state acknowledges that sexual battery under the provision in which Brown was charged is a strict liability offense where no multiple culpability is required, and acknowledges that the Ohio Supreme Court narrowly held in State v. Nolan that attempted felony murder is not a recognized offense. Contrary to Brown's assertion, however, Nolan did not hold that one cannot attempt any strict liability offense, and Brown's expansion interpretation of Nolan should be rejected. In our brief, we cited to the statutory rape statute and said that the court need look no further to that statute to determine that strict liability sex offenses under the chapter of 2907 may inherently be attempted. Statutory rape is a strict liability offense. A defendant utilized a similar argument that Brown uses here in State versus Riddle to argue that attempted rape of a person under the age of 13 was not a cognizable offense. The crux of the defendant's argument there was that because the statutory definition of attempt required purpose, and because purpose is not a requirement for a violation of statutory rape, that there could be no such charge. There, the court disagreed with the defendant's logic and stated that if this type of offense were so serious as to require the imposition of strict liability, that it was almost inconceivable that the legislator removed attempt of that conduct from the scope of the attempt statute. Since Riddle, Ohio appellate courts have continued to recognize attempted statutory rape as a cognizable offense and affirmed convictions of offenders for such conduct. We're using that rationale to state that attempted sexual battery is likewise a cognizable offense and was sufficiently stated in count 1 of the indictment. It's important to also note that the trial court properly instructed the jury on the definition of attempt. Brown requested a certain instruction on attempt, which included language stating that mere words, in essence, stated that mere words were not sufficient to constitute an attempt. The trial court rejected that instruction and instructed the jury, consistent with the OJI and Ohio Supreme Court law on attempt. Therefore, Brown's argument about mere words being insufficient to constitute an attempt was before the jury, and the jury rejected that argument.
I thought, though, that Brown's argument was not so much whether or not the jury instruction got in, but the ruling was arbitrary because it was based on a hard and fast understanding that only OJI instructions and Ohio Supreme Court instructions, or I guess U.S. Supreme Court, as it translates over, are the only instructions that the judge allows, and that was an arbitrary abuse of discretion to have that rule.
I think that may have been his objection, but there's case law that says that a court should exercise caution in allowing a jury instruction which strays from the OJI, where it is based solely on an appellate court decision, which was never intended to be utilized for a jury instruction, and that's the case here. This language that Brown cited for his jury instruction was drawn solely from the case of State v. Bowers that he cited, and I think that's why the court exercised its discretion and rejected the jury instruction, because it was not drawn from an Ohio Supreme Court case, which it necessarily wasn't a confirmed statement of law. Ultimately, the state would encourage this court to review the entire record and weigh the evidence which was before the jury. The state submits that upon doing so, and reviewing the credibility of the testimony of D.B. and her father Charles, and listening to the recordings of their graphic conversations, Mr. Brown's convictions must be affirmed.
Can you talk about assignment of error 4? The verdict form apparently did not contain the degree of offense. Was the defendant sentenced to the least degree of that particular crime?
As to that argument, the state would submit that that argument is not even properly before this court, and that is because that verdict form was not, Brown failed to object to the verdict form at trial. And he did that, he failed to object to it either prior to the submission to the jury or at the time the jury returned its verdict. And because he had failed to object to that, he forfeited all but plain error on review. And this court is well aware that plain error is to be invoked with the utmost of caution. But also, because he failed to argue the existence of plain error on appeal, the court has repeatedly noted that it will not sua sponte fashion an unraised plain error argument on the defendant's behalf. So we would submit that that argument is not even properly before the court.
All right, then, thank you for your argument today.
Thank you.
Counsel, you'll have 5 minutes for rebuttal then.
Thank you. I'd like to just touch on several things that the prosecutor referenced moments ago, and I'll begin with your comment, Judge, about the jury instruction, and you hit the nail on the head that the issue we've raised is that the judge abused his discretion by arbitrarily taking the position that across the board, no, I don't consider proposed jury instructions, I only take my instructions straight out of OJI. And in listening to the prosecutor respond to your questions, I heard her make reference to the notion that's because this wasn't an instruction that was grounded from, for example, a Supreme Court case, that the judge exercised caution and discretion, when in fact that's the point. No, he did not, with all due respect. I took a across-the-board hardline position that if it's not coming out of OJI, I'm not going to give that instruction. And that is the definition of arbitrariness, and therefore we think that the judge abused his discretion.
Well, if we take that down the road a little bit, what if the judge was correct and did not, well, that's not the issue. What if the judge did not abuse his discretion by failing to give that instruction? Can you back out of that error if you found it was error to have the hardline rule, but it was okay that the instruction was omitted? Then do you have an assignment of error? Do you have reversible error?
I'm not sure I totally understand.
Yeah, because I flipped the sides on it, but
Okay.
let's say that instruction wouldn't be proper,
Okay.
and it was excluded.
Okay.
Does it wipe away any of the error that might have occurred?
No.
Okay.
I think I understand your question. No, the bottom, in other words, if at the end of the day, it would be akin, and this is an off-the-cuff analogy, but in a Fourth Amendment situation, search and seizure, it would be akin to saying, well, they found the drugs anyway. So if the judge is taking a position, I mean, he has a duty to exercise his discretion in considering whether to offer a proposed defense jury instruction. And it doesn't really vitiate that responsibility if it turns out that he would have been right anyway. I think that's what you're asking. So no, I think that it's wrong for any trial court to take that hard-line position that I will only consider offering an instruction that's through OJI, and so by definition, he's not exercising his discretion. I want to move on and touch on another point that the prosecutor commented, and that's that essentially the state is now arguing that words can be synonymous with conduct. And that is would represent a dramatic change, a sweeping change of what Ohio law currently stands for. All of the cases that's cited in both parties' brief, and frankly, all of the case law out there that is interpreting what constitutes an attempt, including the statute itself, refers to conduct. We cannot criminalize words alone. Imagine a situation if I were to say to somebody, I'm so angry I'm going to punch you in the nose. Without any more, under the state's theory, I've now committed an attempted assault. And that is, not only is there no current case law to support that position, but it runs contrary to, as I said, all of the cases that have been cited by both sides here. They're all crystal clear that to criminalize an attempt, there has to be some conduct, or we're going to go down a rabbit hole here where we're criminalizing somebody's words alone, and that's not what is contemplated by the statute. And again, I just want to emphasize this notion that, to your point, Judge, about the grounding imposed as a result of other unruly behavior. And I think the prosecutor agrees that's in fact the case here, imposed for other unruly behavior. And we've cited in our reply brief a number of specific instances where the complaining witness's behavior was in fact, she was largely free to do what she was doing, going to work, calling her grandmother, going to the police, etc. So we have a situation where we have some marginal infringement of her freedoms because of her unruly behavior, and the state now wants to argue to you that that behavior constitutes a substantial step, a significant substantial step towards the completion of the sexual battery, just is woefully insufficient as to what would in fact constitute a substantial step. So,
Thank you, counsel. You have
Yes.
used all of your time.
thank you very much.
All right, thank you very much. Court will take the matter under advisement and issue a decision in due course. The clerk of courts will, of course, mail you each a copy of the decision on the day it's released. And the opinions are also posted on the Supreme Court of Ohio's website. Court wants to thank both of you for your presentations today.